I have watched Second Amendment jurisprudence shift before, not through dramatic legislative battles that dominate news cycles, through appellate court decisions that dismantle regulatory frameworks so quietly that most gun owners do not realize the legal landscape has changed until they try to exercise rights that were prohibited yesterday but are protected today. A federal circuit court just issued a decision that invalidates state-based carry permit systems and residency requirements for concealed carry licenses. The ruling does not affect one state or one specific regulation. It establishes constitutional principles that apply nationwide and undermine the legal foundation for every carry restriction, that treats residents and non-residents differently or gives officials discretion to deny permits based on subjective criteria. The case is Holloway v. Attorney General of New Jersey, decided by the Third Circuit Court of Appeals. The plaintiff is a Pennsylvania resident who applied for a New Jersey carry permit and was denied because New Jersey law requires applicants to be state residents and demonstrate what the state calls justifiable need. That second requirement is discretionary. Officials evaluate whether the applicant has shown a particularized threat that distinguishes them from the general public. Most applications are denied because most people cannot prove they face greater danger than anyone else. Holloway argued that both requirements violate the Second Amendment. The residency requirement denies him the right to carry in New Jersey purely because he lives across the state line. The justifiable need requirement gives officials discretion to deny permits even when applicants meet all objective qualifications. The Third Circuit agreed on both points and struck down the law. The opinion is 87 pages and traces the history of the right to bear arms from medieval England through the founding era to Reconstruction. It applies the analytical framework established by the Supreme Court in New York State Rifle and Pistol Association versus Bruin, which requires courts to evaluate gun regulations based on text, history, and tradition, rather than interest-balancing tests that weigh public safety against individual rights. Under that framework, if the Second Amendment's plain text covers the conduct being regulated, the government must prove the regulation is consistent with the nation's historical tradition of firearms regulation. Modern policy preferences do not matter. Crime statistics do not matter. What matters is whether similar restrictions existed when the Second Amendment was adopted in 1791 or when the 14th Amendment applied it to the states in 1868. The Third Circuit conducted that historical analysis and found no tradition of residency-based carry restrictions. In medieval England, travelers carried arms for protection on public roads. Statutory provisions from the 1300s explicitly protected the right of travelers to bear arms. When American colonies adopted English common law, they incorporated those protections. During the founding era, no state restricted the right to carry based on residency. Visitors and residents had the same rights. The court examined every gun regulation from 1791 through 1868 and found 0 examples of states denying carry rights to non-residents while granting them to residents. Some jurisdictions prohibited concealed carry entirely, but those laws applied equally to everyone. Some required permits, but the permits were available to residents and visitors on the same terms. The modern practice of treating non-residents differently has no historical foundation. This matters because millions of Americans cross state lines regularly for work, travel, and family reasons. Under residency-based permit systems, their Second Amendment rights evaporate the moment they leave their home state. A person who is licensed to carry in Pennsylvania becomes a criminal if they carry the same firearm across the border into New Jersey. The court ruled that constitutional rights cannot be conditioned on geography in this manner. The opinion also dismantles discretionary permit systems, the so-called may-issue regimes, where officials have authority to deny permits based on subjective judgments about whether applicants have shown sufficient need. The court found no historical tradition supporting such systems. When states required permits historically, the permits were issued based on objective criteria like age, residency, and criminal history. Officials did not have discretion to deny permits to people who met those criteria, but could not prove they faced special dangers. The Supreme Court already addressed this issue in Bruin, which struck down New York's discretionary system. But several states responded by replacing explicit discretion with other mechanisms that achieve the same result. They created lists of sensitive places where carry is prohibited, and those lists were so extensive that carry became effectively banned everywhere. They imposed training requirements so burdensome that obtaining a permit became impractical. The Third Circuit rejected all of those workarounds. The opinion states that governments cannot use procedural obstacles to nullify constitutional rights. If a permit system is designed to make permits difficult to obtain rather than to screen out genuinely dangerous individuals, it violates the Second Amendment regardless of how the restrictions are labeled. The decision affects multiple states immediately. New Jersey, New York, Maryland, Delaware, Pennsylvania, and the Virgin Islands all fall within the Third Circuit's jurisdiction. Their carry laws must now comply with this ruling. But the precedent will influence courts nationwide because every federal circuit must apply the same Bruin framework. And this decision provides the most detailed analysis yet of how that framework applies to residency requirements and discretionary permit systems. According to early indicators from legal organizations tracking Second Amendment litigation, at least 8 other states have carry laws that conflict with the Third Circuit's reasoning. California, Hawaii, Massachusetts, Connecticut, and Rhode Island all maintain residency requirements or discretionary permit systems. Those states now face lawsuits that will cite Holloway as binding or persuasive precedent depending on the circuit. The opinion also addresses sensitive places, the locations where even licensed carriers can be prohibited from bringing firearms. The Supreme Court in Bruin acknowledged that governments can prohibit carry in sensitive places, but it emphasized that the category must be defined narrowly based on historical precedent. Courthouses, legislative chambers, polling places, and schools had historical restrictions, but modern states have declared entire categories of property sensitive, including all parks, all public transportation, all places of worship, all entertainment venues, and all private property unless the owner explicitly allows firearms. The Third Circuit ruled that these expansive bans violate the Second Amendment. Sensitive places must be truly sensitive, meaning locations where historically there were restrictions or where the nature of the activity creates specific risks that justify disarmament. Declaring half of public space off limits does not satisfy that standard. The court noted that if states can prohibit carry in most places, the right to carry becomes meaningless. The decision invokes the 14th Amendment's equal protection and privileges, or immunities clauses. These provisions prohibit states from denying citizens the rights and protections enjoyed by citizens of other states. When New Jersey allows its residents to apply for carry permits but denies that opportunity to Pennsylvania residents, it creates a class system where constitutional rights depend on which side of a state border you happen to live on. The privileges or immunities clause has been dormant for over a century, but it is experiencing a revival in Second Amendment cases. The clause was designed to prevent exactly this kind of discrimination, where states grant rights to their own citizens while denying them to citizens of other states. The ruling also examines crime data and public safety statistics. Permit holders commit crimes at rates far below the general population. In states with shall-issue permit systems where licenses are granted to anyone who meets objective criteria, there is no evidence of increased crime. The court concluded that discretionary systems do not enhance public safety. They simply reduce the number of law-abiding people who can exercise Second Amendment rights. This creates what the court calls a constitutional dead zone. A person can be trusted to carry firearms in their home state, but is suddenly deemed too dangerous to carry the moment they cross into a neighboring state. The same person, with the same training, the same background, and the same firearm, becomes a criminal based solely on geography. The decision establishes a 3-part test for evaluating carry restrictions. First, does the restriction burden conduct protected by the Second Amendment's plain text? Carrying firearms in public for self-defense is clearly protected. Second, is the restriction consistent with historical tradition? Residency requirements and discretionary denials are not. Third, does the restriction violate equal protection by treating similarly situated people differently based on state citizenship? Laws that grant rights to residents while denying them to non-residents do. If a law fails any part of that test, it is unconstitutional. States cannot save unconstitutional laws by arguing they serve important policy goals. The historical analysis is not a balancing test where courts weigh rights against interests. It is a gate. If the regulation has no historical analog, it does not pass through the gate. The implications extend beyond carry permits. The reasoning applies to any state law that treats residents and non-residents differently regarding firearms, waiting periods that apply to non-residents, but not residents, purchase limits that restrict non-residents more severely. All of those laws are now vulnerable to challenges based on this decision. The economic and political consequences are substantial. States with restrictive gun laws attract residents and businesses that prefer those policies. States with permissive gun laws attract different populations. If residency-based restrictions are eliminated, that sorting mechanism weakens. State policy differences become harder to maintain when constitutional rights must be recognized across borders. For gun owners, the practical impact is immediate. Reciprocity, the recognition of out-of-state carry permits, becomes constitutionally required rather than optional. States can still impose objective requirements like background checks and training, but they cannot deny recognition of another state's permits simply because they disagree with that state's standards. This moves the country toward de facto national carry standards. As more courts adopt the Third Circuit's reasoning, states will face pressure to align their permit systems. Shall issue in constitutional carry, where no permit is required, will become the norm. May issue systems where officials have discretion will disappear because they cannot survive the historical analysis that Bruin and Holloway require. The decision does not guarantee universal carry rights. States can still prohibit carry by people with violent criminal histories, mental health adjudications, or other disqualifications that have historical precedent. They can require permits based on objective criteria. They can regulate the manner of carry. But they cannot use subjective judgments about need to deny permits to people who meet objective standards. And they cannot deny rights to non-residents that they grant to residents. This is the end of an era for discretionary gun control. For over a century, some states operated on the assumption that the Second Amendment did not constrain their authority to regulate firearms as they saw fit. That assumption survived because the Supreme Court did not seriously engage with the Second Amendment until the 2008 Heller decision recognized an individual right to keep arms in the home. Bruen extended that right outside the home in 2022. And now Holloway in 2025 is dismantling the residency and discretion-based systems that states use to limit who could exercise that right. The momentum is irreversible. Every circuit must apply the same constitutional framework. Every state must defend its laws based on historical tradition rather than modern policy preferences. And millions of Americans now have stronger claims to carry firearms across state lines than at any point in modern history.